A major spy case in the UK has collapsed, and the reasons behind this, sparking political fire, raising serious questions. Two men, Christopher Cash and Christopher Berry, who were accused of spying for China, had all charges against them dropped last month. A move questioned by the ministers, the MPs, legal experts. In a rather unusual move, the UK's Director of Public Prosecutions has now stepped forward to explain why the prosecution could not continue. According to him, the Crown Prosecution Service made repeated attempts over many months to obtain evidence from the government that China should be officially classified as a national security threat. However, the witness statements provided did not meet the legal threshold necessary to proceed with the prosecution. Prime Minister Keir Starmer weighed in, saying that the government could only rely on assessments from the previous administration, which had referred to China as a challenge, but did not formally label it a threat to national security. Parkinson explained that at the time the charges were first brought in April 2024, there was sufficient evidence to prosecute, but a precedent set by a separate spying case earlier that year had raised the legal threshold required under the Official Secrets Act. Under this law, for espionage charges to stick, the country involved must have been considered a national security threat at the time of the alleged offences. The UK government has repeatedly expressed its frustration over the trial's collapse. Parkinson's detailed explanation coming after weeks of speculation as to why the prosecutors were unable to move forward. And the case has also drawn criticism from Conservative leader Kemi Pedanoch, who has claimed during her party conference speech that the Labour deliberately collapsed the trial because the Prime Minister wants to suck up to Beijing, quote unquote. Just to recap, the two spies were arrested in March 2023. The investigation, which involved counter-terror police, accused them of gathering and providing information prejudicial to the safety and interests of the state between December 2021 and February 2023. Under the UK's Official Secrets Act, espionage charges can only proceed if the information passed on could be useful to an enemy. The need to classify China as a national security threat emerged during an earlier espionage case involving 6 Bulgarian nationals who spied for Russia and were found guilty under the Official Secrets Act. The law states that espionage occurs if a person acts in a way prejudicial to the safety or interests of the state and shares information that could be useful directly or indirectly to an enemy. The former Attorney General has now called the collapse of the case a muddle, suggesting that the initial prosecution did not adequately focus on how China would be legally described in court. The UK government has denied any allegations that it withheld evidence or restricted witness testimony. Since last year's general election, the Labour government has signalled a desire to reset relations with China, and this includes visits by the Foreign Secretary and the UK's National Security Advisor aimed at enhancing dialogue and building a long-term partnership. In short, the collapse of this espionage trial has raised serious questions about the UK government's preparedness and the handling of sensitive national security cases. To stay up to speed with the latest news, download the WION app and subscribe to our YouTube channel.